Hi, and welcome back. In this session, we will cover the absolutely fascinating subject of, indeed the subjects of international law. The book covers a lot of ground, talking about many different actors, so what I want to do in this first video is take a step back and talk about legal subjecthood as a general concept and what it entails. We will then move on to talk about statehood, so what gives rise, what are the criteria determining statehood. And in the third and last clip, I want to zoom in on one topic that is not discussed as much in the textbook, which is the question of self-determination and the adjacent question of the rights of peoples. As you know, in this first part of the course, we are taking a doctrinal, a positivist approach to understanding the general principles that govern international law. So within such a legal system, what gives rise to legal certainty? What gives us an answer to the question what is legal and what is illegal, even if, as we have seen before, the question is sometimes more difficult and actually a matter of interpretation. Within such a framework, the question of legal subjecthood or legal personality is an absolutely central one. We can think of any legal system, including international law, as basically a framework that allocates to various legal subjects, on the one hand, rights and on the other hand, duties. For instance, if I buy a car and become the owner of a car, I obtain various rights. I obtain the right to drive the car, I obtain the right to lend it to a friend, I can also smash it if I like. On the other hand, I also accrue various duties. Most notably, I have to pay, of course, for the car, but I also have to register it, pay taxation on it. I also have to obey traffic rules and not drive into another car. This may be a relatively straightforward example, but in a way it works in a similar manner also in other legal spheres, including international law. The important thing to realize here is that if we want to understand what the rights and duties are, we first need to understand who the eligible legal subjects are who can effectively hold these rights and duties. To stay with our example for a moment, if you're a child, if you're a minor under 18, you will not be able to drive a car. You will also not be able to make such a big purchase, which already takes you out of the running to be a legal subject and engage in such acts. While all of this holds true in general also for international law, things are a bit more complicated because, of course, as we have seen, there is no single authority to decide in this particular case who a legal subject is. The main complication that arises from this will be discussed in the second video and pertains actually to this question of statehood and how we recognize, how we determine statehood in the international legal system, which is mostly to the recognition of other states. For now, however, it is important to note, and I would even argue that this is the most important lesson to take away from this session, that states are the primary subjects of international law. Sometimes also referred to as the masters of the treaty, it is the consent of states which is absolutely crucial and absolute prerequisite for any kind of international legal obligation to come about. From a narrow traditionalist standpoint, one might even argue that states are the only real subjects of international law, because other actors, other subjects, completely depend on states and their consent to obtain any right and any duty. Without state consent, other actors would be altogether irrelevant within the international legal system. One of the actors that was recognized quite early on were international organizations, and the chapter dedicates quite a bit of space to discussing various international organizations, their setup, their powers, and I cannot summarize all of this here. What is important to remember is that, as already said, these international organizations depend on states and the powers that they delegate to them for their personality, for the international legal subjecthood. Without specific powers that have been put down in a constituent treaty, international organizations will not be able to operate. And they are in fact limited to the powers that either explicitly or in a sort of implied way were given to them in these international instruments. But despite this theoretically subordinate role, international organizations are absolutely vital to the functioning, to the everyday functioning of international law. Think of international organizations such as the United Nations, with its various branches, the European Union, or the OPCW, the Organization for the Prohibition of Chemical Weapons, or the IMF. All these organizations can and will do a lot with the powers that have been allocated to them and can, in many cases, put considerable pressure on states to behave, to conduct themselves in a certain way. The main reason for this practically elevated role of international organizations, and this is a bit of a recap from the last session, is that states usually have a hard time amending and changing, in particular, multilateral treaties. So international organizations feel quite comfortable, quite secure with these constitutive instruments, and will be able to rely on the powers that have been given to them to then act in an effective way. The narrow traditionalist point of view that only focuses on states and international organizations has come under quite some pressure in recent years, and I would even say has been replaced by the more expanded view that, as you will see here on the screen, includes many more actors. Consider, for example, individuals who, under international human rights law, have specific rights. They can invoke them before domestic, but also before international courts. And they also have duties, for instance, under international criminal law, not to engage in genocide, war crimes, crimes against humanity, that we will discuss in a few weeks down the road. Or think, for example, of NGOs, non-governmental organizations, who in various international organizations such as the UN can obtain observer status, can officially consult and support states in negotiations, for example, of treaties, can submit reports, but who also hold rights under international human rights law, for example, when it comes to the freedom of expression and their freedom to publish a report that, for example, is critical of a government. Corporations also have rights under international law, and specifically under international investment law, which they can also invoke vis-à-vis their hosting state before a World Bank international dispute settlement mechanisms. Finally, and I will address this in much greater detail in the last clip, there are also peoples who also hold specific rights, most notably the right to self-determination, though how this is then realized is another matter. Long story short, in various fields of international law, various subjects that are not states and that are not international organizations hold specific rights and specific duties and are therefore logically also international subjects. However, states can, in principle, give and take away these rights, and they therefore remain the primary subjects of international law. So it is important to make this distinction, even though by now the expanded and more complex viewpoint is arguably the more applicable one. This concludes the first video. I now invite you to have a look at the second one, in which we zoom in on states and in particular on the question of statehood.